Never before has the judicial process been so threatened. It goes without saying that neither the public's vested interest nor the ends of justice would be served if we decline to exercise our special authority as the guardian of the Constitution, and if this matter were to be required to traverse the ordinary and lengthy appeals process. Furthermore, the vigor with which Mr. Zuma is peddling his disdain of the Constitutional Court and the judicial process carries the risk that it will inspire others to similarly defy court orders. It cannot be gainsaid that the longer it is in the interest of justice to grant direct access and to do so on an urgent basis. The Constitutional Court holds that there can be no doubt that Mr. Zuma is in contempt of court. A judgment and order was handed down in favor of the applicant in CCT 295/20. Mr. Zuma was served with the order, and it is impossible to conclude anything other than that he was unequivocally aware of exactly what it required of him. Mr. Zuma failed to appear and give evidence before the Commission on the date so ordered, and similarly failed to file an affidavit in accordance with the chairperson's directive. Mr. Zuma is therefore in blatant violation of the court order made in CCT 295/20. To his peril, Mr. Zuma has not presented any evidence to establish a reasonable doubt as to whether his disobedience of the order was willful and mala fide, and the extent to which Mr. Zuma has attempted to justify his defiance through public statements is of no relevance. The statements were not formally pleaded, so fall to be disregarded. The Constitutional Court can do nothing but conclude that Mr. Zuma is guilty of the crime of contempt of court. Having rejected the applicant's rationale, however, the majority concludes that quantifying Mr. Zuma's egregious conduct to arrive at an appropriate length of sentence is almost impossible task. The question is, what length of punishment is capable of vindicating the authority of South Africa's apex court and the rule of law, while sending a message generally that orders made by a court must be obeyed, and to Mr. Zuma specifically, that his contempt and contumacy is rebukable in the strongest sense. In determining the length of sentence, the majority has considered the unique circumstances of this matter, the nature of the breach, and the extent to which the breach is ongoing. Not only has Mr. Zuma failed to dispute the contempt of court, he has also failed to contest the degree of contempt. Instead, he has aggravated it. The majority judgment orders an unsuspended sentence of imprisonment for a period of 15 months. This, of course, cannot adequately capture the damage that Mr. Zuma has done to the dignity and integrity of the judicial system. And ultimately, he owes this sentence not only in respect of violating the Constitutional Court, but to the nation he once promised to lead and to the Constitution he once vowed to uphold. The applicant sought costs on a punitive scale. It is tried that punitive costs are exceptional and are reserved for instances where a litigant has conducted themselves in a clear and indubitably vexatious and deserving of extreme opprobrium. The applicant submitted that I too cherish the ideal of a democratic and free society in which all persons are as equal in opportunity before the law as they are in accountability before it. So my duty as I hand down this judgment is cloaked in the duty I owe to our Constitution and to the rule of law that undergirds it. I am left with no option but to commit Mr. Zuma to imprisonment with the hope that doing so sends an unequivocal message in this, our constitutional dispensation, the rule of law and the administration of justice prevails. The minority judgment, penned by Theron J. and concurred in by Jafta J., agrees that Mr. Zuma is in contempt of the order made in CCT 295/20, concludes that it would be unconstitutional to grant an order of unsuspended committal in the context of motion proceedings if the committal is not aimed at coercing compliance with a court order.